The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
I'm just inspired by the next generation. I think it's time for a big change.
Banned case for Californian ammunition. One of the instances that California gun owners have been anticipating for a while is the ammunition restriction case known as Rohde versus Bolton Rohde. Supreme Court and Second Amendment. The Second Amendment is a fundamental right that protects individuals from the threat of violence. The Supreme Court has consistently recognized that the Second Amendment is compatible with strong firearm regulations, but the gun lobby has repeatedly sought to invalidate life-saving gun safety laws. Two landmark Supreme Court rulings on the Second Amendment in recent years, District of Columbia versus Heller and McDonald versus City of Chicago, have demonstrated that the Second Amendment is not unlimited. The court ruled in Heller's favor, affirming an individual right to keep handguns in the home for self-defense.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries,
the Heller decision was far from the blanket endorsement of unlimited gun rights that the gun lobby hoped it might be. The last decade of post-Heller litigation has demonstrated that the decision was a limited ruling fully compatible with the many life-saving gun laws that protect us today. In 2010, the Supreme Court heard a case challenging Chicago's handgun ban, and because the Heller decision only applied federally, the Supreme Court agreed to hear the case. In McDonald versus City of Chicago, the Supreme Court held a 5-4 ruling that the Second Amendment applies to state and local governments in addition to the federal government. The gun lobby has sought to expand the Second Amendment to invalidate almost every gun law on the books, often falsely claiming support from the Supreme Court or the Heller case. However, courts across the country have repeatedly relied on Justice Scalia's words to decide that essential gun safety laws are constitutional under the Second Amendment. In siding with the majority of Americans who support sensible gun laws, courts are reinforcing that gun safety laws are not only constitutional, but also critical to keeping communities safe and protecting other constitutional rights, like the freedom to safely assemble in public without fear of gun violence. Since Heller, lower courts have upheld a wide range of gun laws as constitutional, including laws restricting the concealed and open carry of loaded guns in public, bans on assault weapons, large-capacity magazines, and silencers, extreme risk protection orders, and other prohibitions on dangerous people possessing guns, firearm design safety standards, safe storage requirements, waiting period laws, and private sale background checks and licensing laws. Supreme Court's impact on gun laws. Only a little over a year after the Supreme Court's landmark decision expanding gun rights, the new legal norm described by Justice Clarence Thomas in his majority opinion has changed the legal framework for gun laws and raised doubts about the feasibility of gun control measures. This has changed the legal context for gun laws and changed the legal context for gun laws. Judges have been given the responsibility of deciding whether or not the laws are consistent with the nation's historical tradition of firearm regulation, as they are being put to the test in courtrooms from coast to coast. These laws include those that have recently been enacted in the states, as well as federal limitations that have been in place for a long time and have widespread support. According to Joseph Blocker, who is the co-director of the Center for Firearms Law at Duke University, since the Bruin decision, there has been a lot of activity and ambiguity over the Second Amendment. The new approach taken by the Supreme Court, in which lower courts are instructed to determine the legality of laws exclusively on the basis of whether or not they are in some ill-defined sense consistent with historical tradition, is the root cause of the change, which is taking place in a number of different ways. In order to satisfy the new standards established by the Supreme Court for determining whether or not certain gun controls violate the Constitution, the government must demonstrate that the measure in question is consistent with the extensive history of gun control that has been practiced in the country. According to Justice Thomas, we hold that the Constitution presumes to protect an individual's conduct when the plain text of the Second Amendment covers that conduct. It is not sufficient for the government to claim that a rule promotes a significant interest in order to demonstrate that the regulation is justified. Instead, the government needs to demonstrate that the law is consistent with the nation's lengthy history of gun control in order to get approval for the regulation. A statute that prohibits the sale and distribution of assault weapons and high-capacity magazines in Illinois was signed into law by the state's governor, J.B. Pritzker, last month and became effective immediately afterward. The ruling, which resulted in the overturning of a legislation in New York that required handgun licenses, caused the governors of both New York and New Jersey to adopt new limits on firearms. However, in response to the new demands, a flood of lawsuits has been filed by gun rights organizations and individual gun owners who say that the new requirements do not correspond to the Bruen verdict handed down by the Supreme Court. And while they navigated the new legal climate, federal judges cited the June judgment in their own rulings, many of which prevented the implementation of gun regulations. This was done in an effort to prevent further constitutional challenges. Since the beginning of recorded history and up until June of the previous year, politics has been the most significant obstacle standing in the way of passing gun laws for the vast majority of Americans. According to Blocker, restrictions on the use of firearms are not being passed because judges are actively working to strike them down. Rather, this is the primary reason. Because of Bruen, the courts are now taking a more proactive role. Nevertheless, even according to the most stringent interpretation of Bruen, there is still sufficient room to pass the common-sense gun measures that are supported by the overwhelming majority of Americans. Impact of Bruen on gun regulations. New York's new regulations, which were signed into law a few days after the Supreme Court's ruling on the Second Amendment, require that applicants for concealed carry licenses exhibit good moral character and prohibit the use of firearms in certain sensitive areas, including temples, bars, and public parks. The New York State Rifle and Pistol Association, along with 6 private gun owners in the state of New York, filed a challenge to certain provisions of the statute, arguing that the measure violated their constitutional rights. A federal district court in Syracuse, New York, refused the implementation of certain elements of the act by following the rules established in the Bruen verdict as a guide. However, the Second Circuit Court of Appeals affirmed those parts of the statute. The people who own guns petitioned the Supreme Court to hear the case, but the court declined their request. As a result, the legislation continues to be enforced while the legal challenge is being considered. According to the legislation in New Jersey, it is against the law to carry a handgun in some sensitive venues such as public libraries, museums, taverns, and restaurants, as well as on private land. These laws are similar to the bans that are in place in New York. A judge in the federal district court stopped the enforcement of the sensitive place laws a month ago in response to legal challenges brought by gun owners and 4 organizations that represent gun owners. The state may regulate conduct squarely protected by the Second Amendment only if supported by a historical tradition of firearm regulations, ruled U.S. District Judge Renee Bumb. In this instance, the plaintiffs have proven that the defendants will be unable to present any proof of a prior history of firearm control to support the provisions that are currently being questioned.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
Even while the legal fights in New Jersey and New York have included new legislation that was passed in reaction to the court's verdict, the new legal standard established by the Supreme Court poses a threat to federal statutes that were passed before the judgment. This is the case despite the fact that the new legal standard was established by the court. In May, United States District Judge Joseph Goodwin dismissed the prosecution against a man from West Virginia who was facing charges of illegally carrying a pistol with a deleted serial number. Goodwin made the decision to dismiss the case against the individual. The man was charged under a certain statute, and Judge Goodwin came to the conclusion that this legislation was unconstitutional. The judge pointed out that in 1791, firearms were not obliged to have serial numbers, and serial numbers were not generally used either. Because of this, a handgun that did not have a serial number was not regarded as hazardous or unique. In accordance with the finding in the Bruen case, a panel of 3 judges on the United States Court of Appeals for the Fifth Circuit recently determined that a federal law that has been in effect for the past 30 years and prohibits individuals who are subject to a domestic violence restraining order from carrying weapons is unconstitutional. Speaking on behalf of the panel, Judge Corey Wilson remarked that the government did not adequately demonstrate that the restriction imposed by the act was in line with the nation's long tradition of regulating firearms. Using a quote from Justice Thomas's point of view, Judge Wilson referred to the statute as an outlier and stated that our forefathers would not have accepted it. Challenges and implications of the Bruen decision. Justice Department officials plan to appeal the decision, according to Attorney General Merrick Garland. It could request a new hearing before the whole Fifth Circuit or petition the Supreme Court to hear the case. According to Blocker of Duke's Center for Firearms Law, restrictions like the domestic abuse firearms law are now seen as valid and even essential. You won't always find laws that directly disarm people for intimate partner violence in the founding era, he added. Legislators weren't very bothered with it, but it would be ludicrous to claim that we can't do it now just because women weren't given the legal protection they deserved then and now in 1791. Although there is bipartisan support for some gun control measures, such as so-called red flag laws that allow courts to issue temporary orders allowing law enforcement to seize firearms from people who are deemed to be a threat to themselves or others, the Bruen decision may open the door for legal challenges to those regulations as well. According to Esther Sanchez Gomez, litigation director for the Giffords Law Center, district court judges have had difficulty applying the Supreme Court's Bruen decision, particularly when determining whether a weapon regulation is consistent with the country's historical history. According to her, it invites district courts to become historians in ways they're not equipped to be, she told CBS News. Additionally, a thorough examination of the historical record is necessary, which is a laborious operation even for a professional, and district courts with busy dockets are not well suited to undertake that. When U.S. District Judge Carlton Reeves issued an order in October raising the possibility of appointing a historian to serve as a consulting expert in a case challenging the constitutionality of a federal law prohibiting felons from possessing firearms, the challenge for judges in applying the new so-called historical tradition test spilled into public view.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
If we can reach compromise on guns, we ought to be able to reach compromise on other critical issues from veterans' health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
This court lacks historical training. Despite their distinction, the Supreme Court's justices lack formal training in history. We lack the intellectual and methodological expertise that historians have, he remarked. Judges go through evidence in a different way than historians do when they examine sources and research methods. Furthermore, we lack expertise in the perspectives of white, well-off, and male landowners on the control of weapons in 1791. In the name of constitutional adjudication, however, we are now required to play historian. As many court battles over new state gun regulations are still in the early stages, judges have been urged to halt the enforcement of the laws while the cases are being heard. State and federal efforts to impose stronger gun limits are nonetheless dogged by their difficulties in applying the Supreme Court's new legal standard and recent rulings rejecting both new and old laws. Advocates for stricter gun control, though, argue that politicians shouldn't be deterred by the possibility of court disputes. According to Sanchez Gomez, legislators should be taking Justice Thomas at his word and comprehend that Bruen is not a regulatory straitjacket. It feels like a game of negotiating with yourself at the cost of many lives to do nothing in the wake of the violence out of fear that it could be questioned. Let's discuss Bruen, comprehend what it implies, but given that it's still a work in progress, it isn't helpful to focus too much on the exact outside borders. Significant developments in Roti versus California case. Since February, there has been very little noteworthy news surrounding the case of Roti versus California, with Judge Benitez remaining silent, not only on this topic, but also on other cases, such as the military Bonta and the Duncan B. Bonta cases. But recently, an order by Judge Benitez brought about a significant change in the situation. It came as a surprise and was of great importance because the order stipulated that the Roti case would be consolidated and that a hearing on the merits of the case would take place on July 17th. According to the order, Judge Benitez was going to not only examine the move for a preliminary injunction, but also hold a consolidated hearing on the merits of the matter. This hearing was going to be held simultaneously with the motion for a preliminary injunction. This indicated that he possessed the authority to potentially settle the entire matter and hand down a conclusive verdict. Many people were taken aback by this sudden turn of events, which is reflected in recent headlines regarding the case. In addition, the state of California just sent Judge Benitez its response, which indicated that they were not anticipating a lengthy trial on the merits of the case. It is essential to be aware that Roti v. Bolton focuses on the laws that the state of California has in place regarding the acquisition of ammunition. The state has adopted two different kinds of eligibility checks: the basic eligibility check and the standard eligibility check. Each type of eligibility check has its own set of expenses that are payable to the state of California. Significant interest and conjecture have been ignited as a result of recent developments in the case, as well as Judge Benitez's decision to merge the cases and hold a hearing on the merits of each. It is not yet clear how this lawsuit will play out or what effects it will have on the state of California's regulations governing the purchase of ammunition. Challenging California's ammunition regulations. The regulations governing ammunition in the state of California have made it more difficult for citizens to acquire ammo online and have it delivered to their homes in an easy and quick manner. Because of this, wait times have lengthened and fees have gone up, making it more difficult for law-abiding residents to exercise their right to bear guns. In the legal proceeding known as Roti v. California, these restrictions are the subject of an objection. The district court judge who is in charge of presiding over this matter is Roger T. Benitez, who is also known as Saint Benitez by some people in California. In the beginning, he examined the situation and decided to issue a restraining order by using a modified version of the Heller test that was influenced by history and tradition. This was referred to by Judge Benitez as the simple Heller test. The results of this test led him to the conclusion that California's background check rules, which prevented some law-abiding residents from legally acquiring ordinary ammo, violated the Constitution and should not have been in place. In accordance with the Heller test, Judge Benitez may have concluded his investigation at that point. Nevertheless, he went one step farther and investigated the historical context and absence of a precedent that justify California's ammunition background check system and restrictions on house delivery. After the initial ruling, the state of California filed an appeal against the decision, which caused the United Circuit Court to remand the matter of Judge Benitez for further consideration. Since that time, there has been very little new information concerning the case until very recently.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
James commented on the decision, saying she's pleased. Remember, the law as it stands strengthens requirements.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
The ruling that Judge Benitez issued to arrange a joint hearing on the application for a preliminary injunction and the merits of the Roti case was handed down recently. In December of the year before, Judge Benitez presided over a meeting that brought together the three most significant cases pending in the state of California. These cases were the Miller case, which involved a prohibition on so-called assault weapons, the Duncan case, which involved a ban on magazines, and the Roti case, which involved an ammo restriction. Since the beginning of February, however, there have been very few new developments on these instances. The application for a preliminary injunction and the trial on the merits of the Roti case will now be heard during the consolidated hearing that was just established by the order that Judge Benitez issued. This hearing is set to take place on the 17th of January at 2 p.m. in the city of San Diego. Response and discovery requests in Rohde v. California case. The defendant, Rob Banta, in his official capacity as Attorney General of the state of California, has submitted a response to the court order dated June 30, 2023, which established a consolidated hearing. The answer outlines various points that will be addressed during the hearing and was in response to the order that established the consolidated hearing. The defendant would like to tell the court about particular parts of discovery as well as any requests they may have in this regard, while simultaneously reserving the right to discuss all of the matters outlined in the order. To begin, the defendant has every intention of making a motion for leave to participate in the discovery phase of the case, which has not yet taken place. This involves requesting authorization to question the plaintiffs and declarants about their standing according to Article 3 in particular. Citing New York State Rifle and Pistol Association v. Bruin, the defendant further suggests that the parties be given the chance to participate in expert discovery concerning significant historical facts that would aid the court in analyzing the plaintiff's claim that the Second Amendment applies to them. This would help the court evaluate the plaintiff's claim that the Second Amendment applies to them. In addition, the defendant has the opportunity to present additional documentary evidence in support of claims supporting the constitutionality of the disputed ammunition laws that were adopted by Proposition 63, as amended by Senate Bill 1235 during the hearing. During the hearing, the defendant intends to produce and introduce such exhibits as part of their defense. In a footnote that is included in the Attorney General's response, they make a suggestion that it might likely break Ninth Circuit precedent to hold the trial and rule without allowing the request made by the state of California for additional discovery, depositions, and expert witnesses.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
That's the law. What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
This footnote is of particular relevance since it makes this suggestion. This footnote can be interpreted as a subtle warning to Judge Benitez, arguing that refusing the state of California's intended discovery could lead to reversible mistake. The warning is included because this footnote appears in the margin of the page. As a direct result of this, the state of California plans to make their case on Monday for the authorization of further discovery. These responses and requests for discovery set the tone for the upcoming consolidated hearing in the matter of Rohde v. California, underscoring the need of a thorough study as well as the possible impact of discovery on the court's appraisal of the legal claims that were given to it. California's strategy to delay the Rohde case. In the case of Rohde v. California, the state of California has followed a strategy that is consistent with its previous actions in other instances that are connected to this one, such as Miller and Duncan. In December, they claimed that Judge Benitez should prolong these trials by enabling the plaintiffs to introduce expert witnesses and historical evidence as needed by Bruin. They stated that this would afford the judge more time to rule. Their strategy, in essence, is to push the can down the road as far as possible and postpone the proceedings as far as is humanly possible. The fact that the state of California intends to drag out the proceedings of this case for as long as they possibly can is really interesting to see. At this point, it is unclear whether or not they will be able to convince Judge Benitez of their position during the argument on Monday. They argue that they have the right to the further discovery that they are requesting and that it should be granted to them, since it is vital for their case. The particulars of the discovery that they assert they require are still not quite obvious, and the response that Judge Benitez provides to their reasoning will be very important. This new turn of events is evidence that the state of California intends to drag out the Rohde v. California lawsuit for as long as possible. Their tactic is demonstrated by the fact that they have responded by asking for extra discovery and perhaps delaying the proceedings. In addition, ominous threats have been made, which give the impression that they might make an effort to appeal the case and get Judge Benitez's verdict overturned once more. In the ongoing Rohde v. Banta ammunition ban case, the state of California has just submitted its answer and is actively pursuing strategies to further extend the dispute. In this particular case, it will be important to keep an eye on the length of time they are able to buy by delaying the proceedings, as well as the answer that the judge will provide after that. That's all for this video, folks. See you next time.